number 7 on petition.
Which is on petition?
Yes. Lordship, petition for condoning this delay.
Is it required? Is it required? Because it appears that the impugned order was passed during the corona period, during the pandemic period.
Lordship, an ex-party order.
Whatever it is, the impugned order had passed on 23/12/2021. You are for the?
For the petitioner. Lordship.
आपको इधर आना होगा. You'll have to come this side. क्या डिफिकल्टी है आपको?
Yes, Lordship, neurological deficit due to spinal cord tumor. Lost strength in my learning.
If you have any difficulty, you can sit and argue.
No,
I'll have no difficulty.
thank you. Obliged for compassion, Lordship.
Yes.
Lordship, delay is 34 days. Order was passed.
It is IA number 1 of 2022. Next, since the impugned order has been passed during the pandemic period, in view of the order of the Honorable Supreme Court in the case of so and so, and the order of the full bench of this court in so and so, the revision application will be treated within time. Full stop. IA number 1 of 22 stands 1 of 22 stands disposed of. Yes, come on the merit.
Lordship. Petitioner is father of opposite party number 2.
Yes.
And the petition under section 125 of CRPC was filed by Nana, Lordship, under the guardianship of Nana, the father-in-law of the petitioner. What happened, Your Lordship? And the wife of the petitioner died an unnatural death on 10/7/2017. Petitioner was taken into custody, and then the Nana of the opposite party number 2 took the son of the petitioner to his place. And the petitioner has been acquitted, Your Lordship. I have annexed the order. After that, the petitioner wanted his son back, but he refused and asked him to pay maintenance. Initially he paid some amount, Your Lordship. I have annexed the money receipts, but he insisted that I should keep on sending money. Then when I refused, because my son is a special child, having several neurological problems, is mentally retarded or cerebral palsy patient. I have taken to CNC Vellore twice in 2015 and 16. I have annexed the medical documents. So Lordship, when I am ready to keep my child with me, he can't force me to give maintenance.
What was the compromise reached between when
I was acquitted,
your client and the father-in-law?
Your Lordship, earlier I filed a petition for custody of my child under Guardianship Act, Your Lordship. But our relatives made a compromise. And
Let us come to that compromise order.
Lordship,
Page?
at page 18,
Yes.
आवेदक की ओर से वकालतन हाजिरी साथ एक आवेदन साथ शपथ पत्र अंडर ऑफिस और अंडर रूल 23(1) CPC के अंतर्गत प्रविष्टि कर प्रार्थना करते हैं कि आवेदक एवं विपक्षियों के बीच आपसी सहमति बन गई है, अतः इस वाद को आवेदक वापस लेना चाहते हैं। अतः इसकी
You should
अनुमति
have enclosed the copy of the petition under order 23 rule 1 CPC. Where is that?
That has not been made available.
That would have only shown.
But the next page, Lordship, I kept on sending money, Lordship, to the
You
Nana
are
of
sending rupees 5,000.
5,000.
He is still minor.
So, Lordship, when the Nana of the child is not in a position to maintain
No,
a special
you
child.
are unable to show that what was the compromise reached between you and your father-in-law. You withdraw the case.
Yes.
You have withdrawn this guardianship case on 19/11/2019. And if you have withdrawn, it means you have given up your case for getting guardianship or the custody of the child.
But Lordship, under section 125 CRPC, Lordship, when the father of the child is ready to keep him with himself, Lordship, and ensure his proper treatment, the money which I have been sending, Lordship, that was not
Let
being
us come
used.
to the- come
That
to
was
the-
not being used in the welfare of the child,
Come to the impugned order.
Lordship. Lordship, at page 36. उपरोक्त वाद भरण पोषणवाद आयोजक मोहम्मद अनस द्वारा धारा 125 दंड प्रक्रिया के प्रावधानों के अंतर्गत भरण पोषण हेतु विपक्षी मोहम्मद फिरोजुद्दीन के विरुद्ध लाया गया है। आवेदन संक्षेप में इस प्रकार है कि विपक्षी आवेदक का पिता है, जिसकी शादी उसकी मां तबसुर नाज उर्फ डोली के साथ हुआ था, जिससे एक बच्चा मोहम्मद एनएस का जन्म हुआ, जो अभी 5 वर्ष का है और दिनांक 12/1/18 से अपने नाना के साथ रहता है। उक्त बालक मानसिक रूप से अस्वस्थ है, इसलिए उसके विशेष लालन एवं सेवा की आवश्यकता है। यह भी कहे कि विपक्षी की पत्नी की हत्या विपक्षी द्वारा किया गया, जिस पर आपराधिक मुकदमा दर्ज है तथा वह उक्त वाद में न्यायिक अभिरक्षा में था। ऐसी परिस्थिति में उक्त बालक असुरक्षित था, इसलिए आवेदक को नाना के साथ रखकर लालन पालन किया जा रहा था। विपक्षी का जूता का व्यापार हजारीबाग में है और वह उससे 50,000 रुपया प्रति माह की आमदनी करता है। इस तरह 15,000 रुपया भरण पोषण के रूप में उक्त नाबालिग बच्चे को विपक्षी से दिलाए जाने के लिए निवेदन किए हैं। विपक्षी की अनुपस्थिति हेतु सम्मन तथा पंजीकृत डाक से नोटिस निर्गत किया गया, लेकिन उसके बाद भी विपक्षी उपस्थित नहीं हुआ, अतः विपक्षी के विरुद्ध एक पक्षीय कार्रवाई प्रारंभ किया गया। अब न्यायालय के समक्ष विनिश्चय हेतु बिंदु यह है कि क्या आवेदक अपने वाद को साक्ष्यों के अधिसंभाव्यता के मानक पर साबित करने में पूर्ण रूप से सफल रही है। आवेदक अपने वाद को साबित करने के लिए 2 साक्ष्यों।
Do you have a copy of the compromise petition which was filed?
Not been made available.
That would be very important.
But Lordship, may kindly consider, Lordship,
Why
I have annexed
didn't you appear in the-
I will annex the medical document.
Why didn't you appear in the court below?
Lordship, for the first time I came to know about this order when I received a notice under section 125 of the CRPC, which is for enforcement of the order. In fact,
What is your statement to that effect?
yes. एक फिल्म ऐसे आइए पिटिशन में तो मैंने पहला पैराग्राफ लिखा है कि द पिटिशन
There is no ground at all in your petition. There is no ground taken in your petition that no notice was served upon you. And the order suffers from violation of principles of natural justice or the procedures which are required to be followed. आप देखिए, not a single line is restricted.
Yes, Lordship, paragraph number 9.
Paragraph number?
9.
Paragraph number 9.
9 at page 5 of the petition, Lordship.
Paragraph number 9 is not a ground.
But Your Lordship, in this case, it has been stated that the said notice issued on 5/3/22 was received by the petitioner on 9/3/22, and only through this notice the petitioner came to know about the order dated 23/12/21.
You came
passed
to know
against him.
about the order. please see the kind of language which you are using. Very carefully you are using certain words.
Lordship.
No, I am telling you, you came to know about the order for the first time after you received the notice. You are not saying that you came to know about this case only after passing of the order, or that during the pendency of this case you had not received any notice.
Maybe, Your Lordship.
Please see the kind of language which you have used.
Because before this date, I was not at all aware of the order, Your Lordship. That is why it
Order
has been
you may
said.
not suppose. आप आज कोई केस चल रहा है, आपको नोटिस भेज दिया, आप नोटिस के बाद नहीं अपीयर कीजिए और 1 साल बाद इस केस में कोई ऑर्डर पास हो जाए, then who will be responsible for this? Whether court should again send you a notice with a copy of the order?
But Lordship, one thing is admitted that this is an
On your own statement you failed.
This is an ex-party order. This is admitted, Your Lordship. This is an ex-party order.
It is an ex parte order
And-
for a
and-
valid reason.
May kindly consider the
It is
Like-
an ex parte order for a valid reason.
may kindly consider the plight of the child.
Kindly consider the plight of the child. I am also saying. You
This
are
special
a
child-
husband who are being prosecuted.
Twice he was taken to a Lordship hospital at Vellore. I ensured a Lordship a treatment.
Two,
Allow-
three things are going against you.
Lordship,
First of all-
the 5,000 rupees which I have been sending was used by his Nana for his own purposes.
I
That
don't
is
know.
why, Lordship, that amount was just stopped.
I don't know.
Lordship, his Lordship, old Nana is not able to, Lordship, take care of a special child. Cerebral
That
con-
is your mere bald statement before this court. That has no basis.
Lordship,
Why the court take into
The cha-
consideration such facts which are not on
the-
the record, which are not proved even prima facie by you?
Lordship, mother of the child is not alive. I did not contract any marriage after the death of my wife. My child is special. And Nana is insisting on sending 10,000 rupees so that
Why
he may
did you
use.
give your application for guardianship? You withdraw your application for guardianship. That too on a compromise. You have agreed. You have agreed to allow the boy to remain in custody of his Nana.
Well, Lordship, I will bring that petition on.
Is it not? You have allowed the boy to remain with his Nana.
Lordship, had that been the case, then amount was not being used in the welfare of the child. That is
That
why,
is-
Lordship,
please try to appreciate how
kindly-
the court can take note of these submissions.
let you kindly.
These are not the matters which the court has to decide on the basis of mere affidavit or on mere statement. I am not sitting in writ jurisdiction where the plea is to be considered on the basis of affidavits.
Like it kindly, Lordship may kindly appreciate the old Nana. Lordship, even if 10,000 rupees is given to the child, he will not be able to, Lordship, ensure his proper treatment at welfare, Lordship. And I am ready to keep my child with myself. I will ensure his treatment. Only because I went to the custody and Nana took
फिर
the
आप
child
इस
with him.
सवाल का जवाब नहीं दे रहे हैं ना आप
हुजूर, वो मेरे
हमेशा
पास-
चाह रहे हैं उसी आपने जब गार्जियनशिप का केस फाइल किया
दो पिटीशन हम रिकॉर्ड पे
तो
ला
आपने उसको विड्रॉ कर लिया एक कॉम्प्रोमाइज के आधार पर एंड डेफिनेटली कॉम्प्रोमाइज वाज दैट द बॉय विल रिमेन इन द कस्टडी ऑफ हिज नाना
तो
सो यू हैव एग्रीड फॉर दैट कस्टडी
एक मौका दे दिया जो उसको हम रिकॉर्ड पे ला दे रहे हैं, Lordship, so that Lordship may kindly.
दैट विल यू नो दिस इज हाउ द केसेस रिमेन पेंडिंग these are the reasons why the cases remain pending जब आपको एक क्वेश्चन होता है ना नहीं आप अकेले नहीं हैं जब भी एक क्वेश्चन होता है आई कैन डिस्पोज इट ऑफ राइट नाउ आपने डॉक्यूमेंट नहीं फाइल किया
I have, Lordship, I have annexed the order, but since I have not annexed the petition, and Lordship wanted to see the petition, to a short adjournment may be allowed. Lordship.
Tomorrow?
I will bring that.
टुमारो
1 week, Lordship. Tomorrow he will have to come, Lordship, from Hazaribagh. Then it will have to be affidavit.
लिखिए Matter has been heard for some time. Full stop. It appears that the petitioner was being prosecuted for the alleged abatement of suicide committed by his wife. Full stop. OP number 2 is admittedly the son of the petitioner, who is in custody of his maternal grandfather. Full stop. Next, the petitioner has been acquitted from the charges under section 498A/34 and 306/34 IPC. Full stop. He had filed an application seeking guardianship and custody of the minor boy, but the said application, being guardianship case number 1 of 19, has been withdrawn on 19/11/2019 on the basis of a compromise. Full stop. Though copy of the order is available as an Exhibit 2, but the compromise petition / application with affidavit under Order 23 Rule 1 CPC has not been enclosed with the said order. Full stop. This court is therefore unable to understand the terms and conditions on which the compromise was reached. Next. Admittedly, the petitioner was paying rupees 5,000 earlier on account of expenses for his minor son, but he is not paying anything for last few years. कब से नहीं दे रहे हैं? For last few years.
टोटल
Next.
4 रुपया दिए हैं, टोटल 30,000।
आप अपियर कर रहे हैं क्या?
नहीं, हम स्टेट
Land Council for the state submits that till date only rupees 30,000 has been
लॉट
provided by the petitioner since the year 2018. Full stop. Next. Neither in the impugned order is definitely an ex parte order, but neither in the pleading portion nor in the grounds raised in the revision application there is any averment at all that the petitioner was not served with the notice during the pendency of the revision, pendency of the maintenance case in the learned court below. To stop, all that is said is that the petitioner got the knowledge of the impugned order after receiving the notice. Full stop. Next, at this stage, learned counsel for the petitioner, you are Mr.
Shitanshu Shekhar Mishra.
Mr. Sitanshu Shekhar Mishra, learned counsel for the petitioner, has undertaken to place on record the compromise petition / affidavit as the case may be within 1 week from today. आप नेक्स्ट डेट के पहले कुछ कहिए, पेमेंट करके आना, ठीक है? कभी आप कुछ नहीं दे रहे हैं पिछले 4 साल से, तो कम से कम उसको अभी 50,000 रुपीज कहिए 1 वीक में दे देने के लिए। लड़का तो आपका है ना, माइनर
128 लॉर्डशिप CRPC
माइनर लड़का है ना?
नहीं, लड़का को तो रखना चाहते हैं, इसके लिए हम शादी नहीं करना चाह रहे हैं। हम अंडरटेकिंग देने पे तैयार है कि हम शादी नहीं करेंगे।
आप जो भी करेंगे, अभी इसका तो फैसला आएगा।
लॉर्डशिप अपोजिट पार्टी,
इस केस का फैसला अभी आना है।
अपोजिट पार्टी 2 इज द ओनली चाइल्ड, लॉर्डशिप।
That is why I am saying.
No one other I have to take care of.
That
The
is
only-
why I am saying, provide at least rupees 50,000. You are not paying anything for last
But
4
the
years.
50,000 rupees will not be used in the welfare of the child.
How can you assume everything?
Lordship, I have seen. Lordship, after
लेकिन-
the acquittal, I have seen everything.
Considering
But
that the petitioner has not paid
वो जो-
any amount towards maintenance of the
वहाँ
minor
pending,
child.
वहाँ पेंडिंग है 128 में, हुजूर इस पे ऑब्जर्व किया जाएगा तो वहाँ दिक्कत होगी, इसलिए
From
अभी एक
a
सप्ताह के बाद जो
present-
ऑर्डर करना होगा हुजूर उस पे किया जाएगा.
For the present, this court directs that he will pay rupees 50,000 to the opposite party number 2.
हुजूर एक सप्ताह के बाद ये आ ही रहा है हुजूर, उस पे ऑर्डर
For
किया
next date
जाएगा,
of hearing.
क्योंकि नेक्स्ट डेट को
List this case. After 2 weeks, under heading for admission within top 10 cases.
4th of August.
2 सप्ताह दे
हुजूर
दिया.
इस फाइल को हुजूर पेंडिंग है ऑलरेडी 128 पे,
नरेंद्र कुमार।
पेंडिंग है पिटीशन हुजूर, तो ये 2 सप्ताह के बाद जो ऑर्डर होगा इस-
नरेंद्र कुमार सिंह
128 का पेंडिंग है तो क्या होगा उसमें? क्या होगा बताइए?
तो वहाँ हम अपियर कर गए हैं, वहाँ कोर्ट
क्या होगा 128 का, क्या होगा
वहाँ
उसका
कोर्ट
स्कोप?
वहाँ कोर्ट बिलों का जो ऑर्डर होगा हम उसको कंप्लाई
तो
कर
ऑर्डर जब से अल्ट्रेशन होगा तभी तो.
हाँ,
आज की तारीख में तो ये ऑर्डर एग्जिस्ट कर रहा है ना. कोई भी प्रोपोजिशन टेस्ट कीजिए ना, ऐसे बोलने से नहीं होता है. आप 128 में गए हैं तो क्या फर्क पड़ जाएगा उससे इस इम्प्यून्ड ऑर्डर को? अभी तो एज ऑन डेट इट एग्जिस्ट. कैन दिस ऑर्डर बी अल्टर्ड विथ रिट्रोस्पेक्टिव इफेक्ट?
नो
इट
लॉर्डशिप,
कैन नॉट बी.
बट सिंस आई हैव अपीयर्ड देयर सो
तो कुछ भी बहस मत कीजिए.
लॉर्डशिप 2 सप्ताह के बाद यही ऑर्डर
नहीं नहीं नहीं, कोई सिंपैथी की बात नहीं है.
नहीं, सिंपैथी मेरे साथ नहीं, बच्चे के साथ सिंपैथी होगी.
अपने बच्चे को पैसे देने में इतनी दिक्कत हो रही है।
यहाँ तो सब वही केसेज आ रहा है. बच्चे को देने में दिक्कत है, वाइफ को देने में दिक्कत है.
ये नाना को दे दे.
Item number 8.
बच्चे
Some defects are yet to be cured. The